Hi, everyone. Good evening. Carl Steinbeck here. Want to talk about the Karen Reed case and the motions that were last Thursday, the 20th here of March, 2025. There was a flurry of them. Some of them we don't really need to cover, but the main ones that I want to talk about, and there's one that's really, really explosive, and it's going to have a lot of second, third, fourth order effects that I don't even think Brennan understands, because it's very much something that's going to I think blow up in his face if he gets his way. So the first one had to do with motion to stay the proceedings until the First Circuit, which is a federal circuit court of appeals, is hearing the issue of whether the jury, having not formally announced a verdict of not guilty on the first and third count for the cause of action against Karen Reed, should be tantamount to a not guilty verdict. I do not think that's going to be granted on appeal by the First Circuit. The judge wound up uh, denying the motion, even though Brennan was not so opposed to it. And so what happened was, I think with the jury selection going to be taking a while, I think in the end that'll wind up not being such a conflict. But I do think that the federal courts are probably frustrated by the fact that she won't grant a stay when it was really not something that was a big deal to grant. Other than the fact that the jurors, summoning jurors, I guess would be the biggest issue of hardship that she made as the reason why she denied it. But in the end, I don't think it's really going to matter, because I don't think federal courts are going to stick their neck out and override state law on what constitutes a verdict. So I think what should really happen is the due process of someone. When you can't get a single juror to convict you, why would you want to retry that? Um, and by you, I mean the defendant here. If you're a prosecutor and you have a defendant and you can't even get a single juror to vote to convict on your most serious charge, to go at it a second time is just really abuse of power. That's what it really amounts to: abuse of power, lack of respect for not having to put somebody through that kind of meat grinder again. So what we had then, the next one was Commonwealth's motion for a buffer zone. So they're trying to keep a buffer zone of the pro Karen Reed folks away from the courthouse by a certain degree. That was taken under advisement, and so the defense did not have any opposition to that. Next one was 593, defense motion in limine to allow evidence for lack of bias by the ARCA uh, subject matter experts, those two doctors that testified. And what was something that I think it probably would have resulted in a probably not guilty being clarified, and at least on the second degree murder charge, and the third one by the jury, because we still had that troublesome foreman of the jury. But I think we heard that from at least one of the jurors that spoke out afterwards. This thing about the ARCA witnesses not knowing who they worked for, who hired them, that was something that they were told to disregard. Well, it's sort of like throwing a skunk in the jury box and then telling the jurors not to smell it. They're going to keep wondering, and the more you play hide the ball and keep away with that, then I think it's going to be one of these deals um, that could have made a really difference in the outcome of the case first go round. And now the second go around, and by the way, I should say that the only reason the prosecutor wanted to keep that out, Lally, at the time, was because it gives them instant credibility, the fact that the FBI hired him. There's no other reason. There's no confusion of the issues. The prosecutor knew that this was something that gives them instant credibility in front of the jury. And so in essence, by them not being told who they worked for, who hired them to do their inquiry, it makes it look like there's something shady going on with the defense. So it actually hurts the defense. And so that's why I think if they would have known this was done by the U.S. Attorney's Office, Department of Justice, that they trusted these guys to give them a straight answer, there's no bias or no defense shopping around trying to find somebody to say what they want to hear. So that really was a massive blow to the defense. And I wish they would at least on when they um, brought them up as and started questioning them, they would have brought up the fact that they had been hired by the Department of Justice / U.S. Attorney's Office, and not specify this case, but at least to give them some kind of credibility like that. So on this particular motion, what we had for Brennan then saying that I guess he was conceding he was conceding that the FBI, uh, Department of Justice, U.S. Attorney's Office hiring of these experts could come out, but he wanted to have full disclosure on every form of communication that took place between ARCA and the defense. So it wound up being what the judge said that she's going to have a voir dire the day before they testify. So a voir dire is like out of the presence of the jury, and have them basically uh, be subject to scrutiny at that time. And she said because of Rule 14, when the defense said, well, why would we need them voir dired? So basically, what the judge is doing is trying to help the prosecution come up with evidence against the ARCA witnesses that could be used against them to try to incriminate them. Because what the judge is essentially doing is saying, I don't trust the defense team to accurately say what communication happened with these ARC witnesses. So we're going to put them under oath to find out exactly what happened and make them compare what information the defense has provided as a part of reciprocal discovery. So it's a real pro prosecution move by the judge. The prosecution wasn't even asking for it. So she's basically helping push the scales of justice against Karen in a very pro prosecution manner. So I thought that was very much a another indicator that you're not going to get a fair trial in this court. And for them to testify, also, I caught that Brennan said that he wants to explore the bias of these witnesses, or words to that effect. So by him mentioning bias with these ARCA witnesses, I'm thinking that what he's actually doing is chilling and intimidating these witnesses from wanting to come forward and assist in their testimony and reveal what they perform for experiments. These are such highly qualified experts. To have some kind of state attorney refer to them as being biased, I thought that was very, very much something that could be tantamount to intimidation and in encouraging them not to cooperate. You could have a chilling effect on their willingness to be able to cooperate on this case, because if the prosecutor's calling them biased, they run a business, they do this from a neutral standpoint, because if they were biased, they wouldn't have any line of work lined up for them. So their credibility, their core value is to be unbiased. And so for him to bring that up, it's really a shameful thing. And it's sad to see that, that's what Brennan's going to do for any defense witness, say that they're a biased expert, if that's what they're called to testify to, is their expertise. So it's just really a slash and burn, low blow to do that kind of accusation against these highly capable, neutral type experts. And I would say that it's just very much a sign of how ugly this thing is going to get on hiding the truth from the jury. So the only way the prosecution can win is if they hide the truth from the jury. That's what I think this really comes down to. Next, we had 595 motion to allow counsel to state grounds for objections. This one, Dave Yannetti gave the reasons that they should not have to have sidebars to have this dialogue with the judge on whether the objection should be granted or not. The prosecution should have to state the grounds for their objection, because what it really amounts to is it's taking more time because they have to have sidebars. Although I would have argued that even more strenuously and say what Lally's has done, and what no doubt the new prosecutor will do, is just every time there's a good point to be raised through a witness, they're going to object. And it doesn't even matter what the objection's for, because you don't have to come up with a reason. The judge can pretty much 95% of the time grant the question to be answered, and never says overruled. They never brought the fact that the judge is biased. It always says I'll allow it, instead of saying overruled. So anyway, I just thought it was very much a accurate motion, but I think I would have put more argument behind it and show how unfair it is. And in this particular case, the judge has summarily denied it without any explanation. She just denied it. So that was disappointing to see. Next, we had motion to exclude false and irrelevant statements of Proctor. That was granted since the Commonwealth does not intend to admit. So that leads you to wonder whether they're even going to call him as a witness or not. So let's see here. And then we also had defense motion for reconsideration of the order denying motion to exclude the testimony of the Commonwealth's witness, Dr. James Crosby. This is the government's expert that they want to use to try to explain dog bites, and he did some sample tests and supposedly met with this Chloe dog to try to see how her teeth would have matched up and all this kind of stuff, which I think is so far-fetched and not any kind of reliable science. So the judge on that said she was going to wait to rule until Dr. Russell's testimony. That Dr. Russell's testimony was in the first trial, and that was the defense expert who explained the injuries as dog bites that are on the arm of John O'Keefe. There was another motion about prohibiting the state police and the D's officer from having jury contact. That was granted for both sides, and the judge made sure to add that it also applies to the defense. There's another one having to do with an exhibit that I want to talk about. There was also one Commonwealth motion to appoint a court stenographer and prevent the identification of jurors and impound jurors' names during the trial. That was also taken under advisement. And it also was a point that it sounded like they didn't want to have any of the prosecution didn't want to have any of the objections and sidebars being have any chance of being not just heard by the jury, but also not being allowed to be broadcasted. So that's what I think. That's why I took that to mean it wasn't quite clear what they were talking about. And then this other one, this Commonwealth motion to redact the manner of death. So here the Commonwealth is trying to strip from the jury saying that the cause of death was undetermined and they couldn't put homicide on there. So the fact that the death certificate doesn't say homicide, they want to keep that out. I mean, that's so favorable to the defense. So I would say that this is another example of how they want to hide the ball from the jury and get a conviction by keeping all this reliable, relevant, constitutionally required evidence from coming in. So that's something that that was taken under advisement. I mean, that shows you how much you're not going to get a fair shake. That should have been like laughed at by the judge. Of course, that's coming in. So, and then also the Commonwealth has a motion with the intent to obtain the crime records check on all jurors that are coming into court there. So they want to be able to cherry pick and go after these people to see if they're not being honest on their jury questionnaire as to whether they have a criminal background or not. So they basically don't. All right, so you need to. This is a clean channel, so I'm going to put you in timeout. We don't need any foul language on this channel, so this is going to be run professional as if we're in court, and so please follow the guidelines that I set up on the channel. We also have. So anyway, the fact that they don't even trust the jurors and they're trying to make sure that no one's ever had some kind of negative experience with law enforcement before. They want them off the jury. So that's sort of backdoor way of avoiding a confrontation with them and trying to have those probing questions on what was your experience like when you got arrested? How did the law enforcement and the prosecution office treat your case and stuff like that? So it's I think that it's something I've never heard of before, that you're going to do a background check on potential jurors. It just shows you the scorched earth mindset of Brennan. Then there's also a Commonwealth motion to admit victims' out-of-court statements to the state of mind. So that was also taken under advisement. And again, she's looking for ways to justify, I think, granting that motion. Now, there's an example here. There was discussion of third-party culprit, and we actually had the defense state the three names that they were wanting to allege was the third-party culprit, and the prosecution then, Brennan was saying that they've had public statements saying that we know who this was, who actually did this murder, and then and another time they said we don't know who did this, and that was said by almost simultaneously at the same time. by defense counsel and Karen Reed. So that was something that I thought was, not a good strategy to do all this public speaking, especially if you don't have the same answer consistently throughout. So, and that's going to lead into something else, the last motion I'm going to talk about. Then there was also a Commonwealth motion to allow Cellbrite demonstration. I don't have a problem with demonstrations per se. That was also taken under advisement. And then the Commonwealth also wanted to exclude expert Michael Easter's opinion of the investigation. So a retired FBI investigator wants to talk about how this investigation was such a botched thing. It's just what I've been saying. It wasn't an investigation. So the lack of proper police protocol, investigation tactics and techniques was something that she had to take under advisement. So, I mean, she didn't even know that this is something that is routinely done in other jurisdictions. So again, I think it's another thing that um, that is just really troubling. That the truth of how bad this is, there was not a law enforcement expert to talk about this botched investigation, quote unquote. And so I think that again, they're wanting to keep the truth out of how bad this is, and they're maybe not going to even call Proctor, make the defense call Proctor. So it's just all hiding the ball from the prosecution, and it's really disgusting to see. And then the very last one here, I want to show this here. This one is the prosecution's motion to compel communication between the defendant and attorney Yannetti stored within the defendant's cell phone data. So what they want to do is take Karen Reed's messages that she had between January 29th and February 2nd. So the day that all this went down and up to a couple days, several days later, they're saying that Karen Reed waived the attorney-client privilege in communicating with attorney Yannetti, who was the local attorney that she first talked to. And they're saying that by her disclosing information to media channels is a waiver of the subject matter waiver of this normal privilege for attorneys. So they talk about how there's a waiver of the privilege, and anyway, I'm not going to go through all the detailed descriptions here of what law that applies here, but I would say this is something that is very rare. It's usually only done in civil cases. I've never heard of this happening in criminal cases, and it's really opening the door to a lot of troublesome things. So they're trying to say that, for example, a recorded interview with Gretchen Voss in June of 2023, they're saying as a defendant concedes, question, you never said I hit him. I hit him. Answer, I said, did I hit him? And then, when I talked to David, now this later, David said, Karen, if you incapacitate him in any way, there's capability there. And I thought, all right, this is what maybe I said to my mother. Just to go forward a second, they were asking me, like, what was it like? Did they come out? What was the house like? And it says Attorney Yannetti, Attorney Jackson, and Attorney Little were in attendance along with the defendant and Ms. Voss. So then they also have a Vanity Fair one where Karen tells her side of the story as a caption. And they're saying that it was published on October 29th, 2024. The defendant, who according to the publication was nobly aware that anything she said could be used against her, volunteered a rumor that alleged representations made by the Massachusetts State Police that there's a text message between her and counsel that implicates herself is a provable lie. So what happened is these messages, if you notice here back to the first page, it says here, pursuant to a search warrant, the Commonwealth received the contents of this defendant's cell phone because of an observed attorney-client communication. The phone data was provided with the assent of the defense to the Attorney General's office, and in a court-ordered team protocol was implemented. The Commonwealth received the defendant's phone data with any privileged communications excised. Given the defendant's public waiver of the attorney-client privilege as it pertains to defendant's conversation with Attorney Yannetti on January 29th and the following 3 days, the Commonwealth is entitled to the communications between the defendant and Attorney Yannetti for this waived narrow period of time. So they're trying to basically get whatever conversation happened between Karen and her attorney. This is like unheard of. I've never seen this, never heard about this in criminal law. I understand it happens occasionally in civil law if the people try to hide behind their lawyer and say, well, my lawyer told me to do this, and there's some kind of embroiled litigation civilly. Here you have like attorney-client privilege, and what you have is this affects constitutionality of Karen Reed's rights, because if you have your attorney and communication between you and your attorney coming forward in the trial, what this is basically going to do is make attorney Yannetti look like he's not a guy to be trusted, because he had communications with Karen where they discussed maybe she had done something, she doesn't remember it, and he said, well, you could still be guilty or something like that. So you got the guy that in a text message said, well, you could be guilty under these circumstances if you don't really remember. And then the same attorney is going to be arguing her innocence in court. I mean, that's a big credibility gap you could have as a defense lawyer. So guess what? You're ineffective. So what this Brennan is doing is he's actually creating an ineffective assistance of counsel, and Yannetti may have to resign and recuse himself from being attorney on this case. Well, guess what? The other attorneys are all there pro hoc vice, meaning they're only there from out of state jurisdictions that they would not be able to practice in Massachusetts, but for the local counsel, Yannetti being there to be the lead counsel. So I know in court they said he's not the lead counsel, but for the purpose of the other attorneys, out of state attorneys being able to practice before Massachusetts courts, if he has to go because of this, then this whole thing, the whole trial may not happen April 1st. There may be a long delay in this. So then it goes on to talk about the ID discovery, the one that we talked about, abiding the snow, and how that they're talking about when she hired Dave Yannetti. So she's again mentioned Dave Yannetti in whatever conversation they had. So what they're saying now is that she waived the attorney-client privilege as to this subject and this topic of what did you do that night, and how would you be culpable for any potential crime. So in any event, they don't sign any more case law other than this one here in the matter of John Doe grand jury investigation from a 1990. So that one has to do with a grand jury investigation. It wasn't a criminal case. So they don't cite any criminal cases where this was upheld on appeal, where they pierced the attorney-client privilege. So this is really scorched earth. It's very, very much par for the course of what you're seeing from the prosecution. They want to reach behind the attorney-client privilege, which is something that is so much a constitutional foundation, bedrock of the jurisprudence of criminal law in America. So I can't imagine a judge allowing this. But when you got this judge there in Massachusetts, maybe he's going to come in, and then the whole thing can unravel, and we won't have a trial April 1st. So that's what this prosecutor doing. I mean, he's going after everything he possibly can. Doesn't matter if he's trampling on rights. Doesn't matter if he's creating new case law. And it's something that I think is something that, again, what I've said before is that getting your client out in front of the media and making statements is high risk maneuver. It's a high wire act. I just don't think it's a good move. And now you got potentially this information coming out, and then the fallout from this could be, maybe you'll get a conviction, but it's going to be a long drawn out process. It's going to be an ugly fight, and you could have ineffective assistance of counsel claim on appeal. So, but I think that the prosecutor, the way he's going about it, he doesn't care how much reversible error he's creating. And by reversible error, I mean that there's such magnitude of an error or errors on the court record of the proceedings that the transcripts printed out for the Court of Appeals to look at, that they'll look at this and they'll think, what the heck was going on here? This thing is out of control. There's numerous constitutional rights that are trampled on. So I think that this is one of those deals where be careful what you ask for, Mr. Prosecutor. So I'm just shocked by this whole thing. I think this thing is really rigged, and Karen doesn't have much of a chance on a lot of this stuff. when you have pro prosecution rulings. So with that, I'm going to go ahead and exit this document. So with that, I'm going to go ahead and take questions now. And so yeah, this thing's going to have some twists and turns that I don't think even the prosecution was anticipating. When they go this cutthroat, you're going to have some blowback. You better rethink what you're doing there, Brennan. Is what I would say to him if I ever met the guy. All right, so if you do have a question, go ahead and put if you know how to put the emoji question mark. Nacho Mom, you're asking, do you think she will change the jury vote sheet this time around? I think it's going to be the same one. And then she's not allowing group for dire. It's going to be individual. And so I don't think there's going to be much changes at all to this document that she will allow. She probably uses this in every single trial, and so she doesn't want to tailor it to any particular new trial coming up. Here we got North Carolina retired state highway patrol officer. Good evening. You're saying the Commonwealth won't be calling Proctor, so all these witnesses, including law enforcement, will obviously be bringing up his name, and the jury will be wondering who he is. Look bad. Well, I think that if the prosecution doesn't call him, the defense should, to show how bad this thing was botched. JB from Florida saying the thin blue line wasn't there for John. So much for camaraderie. Yeah, that's a good point. Uh, retired trooper, sir, you're saying that when the defense calls Proctor, the defense will hammer him, and this case will be over. Every single case I've seen where lead prosecutors fired, all pending cases were dismissed. Yeah, I think that would normally be the case, but here it doesn't matter. They're out for blood, and they want to be able to pin the guilt on Karen. And you're saying firing Proctor will be the most damaging to the prosecutor. The dominoes will fall fast and will cause a not guilty or hung jury without a doubt. Yeah. So why was he fired? He was fired because he had bias, right? The opinion from the uh, state board that decided he was going to be fired said he had the appearance of bias. It was more than appearance. I mean, it was actual bias. You can't get more bias than that, right? Yeah, I listen so much to what Brennan says. It's like he's putting so much spin on stuff, so much spin. Patricia Hernandez, you're saying what I keep wondering is how the Brady violation of metadata can be cured for the second trial if a new trial is remedy for some violations. What happens to this since they not only they never got it? Yeah, I think there's so much hiding the ball on stuff. I don't see this thing sticking on appeal. Even as the top court of Massachusetts said, they did not hear the any request to dismiss this based on insufficient evidence. Dorothy Walters, grounds for objections not being said allows no transparency and her allowances won't be questioned. You don't even have to know of a legal basis to object. Just constantly object. If you're the prosecutor, just constantly object when you know you got testimony from the other side that's hurting your efforts to hide the truth. That's all you got to do is keep objecting. Fire away. It's too late in front of the jury. The objections, they're not going to be able preserve it. They could on appeal, but who cares if you got a conviction based on the fact that evidence was suppressed that should have came out. Yes, I agree with you that they shouldn't be kept out, but I don't trust this judge to make the right ruling on that officer. I really don't. It would be unheard of, but why would she take it under advisement? That's really bizarre. Tall Glass, you're wondering why the Karen Reed attorney hasn't filed a motion to reconsider the attorney misconduct ruling. Well, there was no sanctions issued, so I think they don't want to ask for that to be relooked. I thought also the fact that the attorney Alessi argued it and not Jackson, who was the one that was being accused of misleading the court. The fact that a different attorney argued it makes it look like Jackson had uh, had something to hide, and so I'm surprised the judge even allowed another attorney to address it, and Jackson really didn't have to say anything about it. So I thought that was unusual. But in any event, there may be some punishment as the case is over, and that there's some kind of court finding. So, but as of right now, there is no finding that that limits them from representing Karen. Thankfully. Tall Glass, you're saying the Commonwealth is trying to cut at the knees while still submitting discovery. Yeah, it's this when you have all this documentation that was not uh, preserved. There wasn't photos preserved at the scene. They we don't even have a photo of what John's body looks like there, laying in the snow. Supposedly, where these plastic tail pieces are found on him. I mean, it's just like you could go on and on and on. This is an absolute joke of a case to say that you got evidence beyond a reasonable doubt to convict Karen. And if she says something like, "Hey, did I hit him? I wonder if I hit him," all that kind of stuff. Well, I think she was probably intoxicated so much and she's using hard liquor, so she's probably has a blackout of that, a legitimate blackout. So, but that's you need something more than just somebody saying, "Oh, did I hit him? Did I hit him?" That's not a confession. Even if she says, "I wonder if I hit him," and that comes out in some attorney messages with Janetti, that's not enough evidence to convict her. Thanks, Azen. Appreciate you. Sophie, yeah, it does seem like Brennan is intimidating a lot of people on the defense side. I agree. Okay, Martifana, you're saying I think it was California. They have a thing where several attorneys can get together and put paper on a judge, which is a backdoor way to call attention to an unfit judge. I haven't heard that one before, but I think things are so much politics norm up there in those northeastern very old states that it's a lot of politicking and corruption going on. It's just a way of life up there. Jennifer Rank, you're saying you've read that police and judges have qualified immunity. It can be overcome if the plaintiff can prove that the officer's conduct violated clearly established standards, Sixth Amendment. Yeah, these kind of cases like this, you'd have to really show that they hid evidence. Um, they try to railroad an innocent person, but you need more than this. Here you have, they're just not disclosing information, and they don't really know what happened to Kieran Reed, right? I mean, excuse me, for John O'Keefe. They don't really know what happened to him. So they qualified immunity is so hard, high of a hurdle to jump. I just don't see anything ever coming out about this. Unless you had somebody admit that they knew that she was innocent and they try to rig the system against her. Caroline and Leiden, you're saying too much hubris on the part of the prosecution, so now they won't back down or to save face. I agree. I mean, they got the prosecutor they wanted for this. Yeah, Guy Vermectin, you're saying if they had such a slam dunk case, they wouldn't be doing all this. That's what I've said. If you got somebody nailed dead to right, you're a prosecutor. Let them call whatever experts they want. Let them throw whatever they want to have, try to stick with the jury. You can just gut it down on your cross examination. You'll have your own experts to counter theirs. You'll have more credible experts. But the Commonwealth, they're not going to have any more credible experts than an accident reconstruction than the ARCA folks. And they know that. They know this is a loser case. The only way they can win is to hide the ball. That's what it comes down to. Jennifer Rank, you're saying, I'm wondering if the federal government can charge the police officer with crimes regarding conspiracy as they violate her Fourth, Sixth Amendment rights. Proctor's, yeah, he's discussing the way he handled this case. So I think that the, to be charged, you have to have the U.S. Attorney's Office be willing to file charges. So, in the deal with Proctor, him making statements as opposed to, I think, just making statements and not actually punishing her, other than, he didn't beat her up or anything like that. So I think that's going to be harder for the U.S. Attorney's Office to pursue. But that'd be nice if there was something like that. But they already had a federal investigation, and that was not pursued. So I think that that sort of is a dead issue at this point. I found it interesting that, according to what Brendan was saying in court, that the defense was the one providing information the to the federal government that was then given to the ARCA experts, and it's like, why would they be getting that from the defense and not the prosecution? I think that has to do with the U.S. Attorney's Office did not trust the state attorney's office to not be meddling in their grand jury investigation and their independent investigation. They sort of wanted to keep it on the down low. So I think that's really telling that there's lack of trust there of the state attorney's office. Okay. I'm just wondering here. There's a okay. Let me just say right here, D. I'm not afraid to take you on. You're saying you have zero respect for me supporting a murder Karen Reed and likes the Turtle Boys. First of all, I've not gotten involved in Turtle Boy at all. So you're accusing me of supporting a guy who just released a prosecutor's home address. So I've not done that. So why don't you get your facts straight? And as a fellow attorney, he should be ashamed. Okay, you're an attorney, so obviously you don't know criminal law, and obviously you don't know the Constitution, and you obviously don't know burden of proof. You obviously don't know enough of details of facts of the case, and so you're just somebody that I'll address you now, but I will I'll just say you have no idea what you're talking about, and so saying that I should be ashamed to have an opinion that's different from you, and I'm talking about the facts. So anyway, I'm just gonna zap you. Okay, if you have no problems with what's going on with the way Karen Reed's being treated, you know, if something like that happened to you, man, would you be crying? Oh, I've seen that happen before. People like you, when it happens to you and your family members, boy, do you change your tune. And so, anyway, you're probably just somebody. You're doing the same thing you're accusing Turtle Boy of doing. You're trying to just basically stir things up. Christy, a painter's daughter, you're saying, "Oh, that's a dangerous area to get into. Attorney-client privilege should not be crossed. If it's allowed, what's next? We should all be afraid." Can you imagine that? You're charged with a heinous crime and you have an attorney and the prosecutor wants to have a communications between you and your client be brought out in open court and read to the jury, that's a scary proposition. I've never heard of that wild, reckless trampling on rights like that before. The Glary, you're saying he's a mob lawyer, so what do you expect? Yeah, that's I guess they that's why they picked him. He's a mob lawyer and he knows how to fight he knows how to fight a different way than normal state attorneys. Jennifer Rank, you're saying why would Bev want to have the public cast out in every case she oversees? Has everyone seen the microdot videos? I haven't seen all of them, but boy, yeah, there's those videos were really troubling, and recommend folks look at them. They have some theories on what happened there, on what, but in any event, I'm not saying who did the crime against John O'Keefe. It's reasonable doubt. That's what I'd be arguing if I was defense counsel. You don't need to point the finger at anybody. And I think that what Brennan's doing on this piercing the attorney-client privilege, he's trying to use this third-party culprit as a basis to try to pierce that attorney-client privilege, to say that, well, if you have some kind of conversation where it sounds like Karen might be wondering if she did it, and then her attorneys are saying no, a third party did it, three different culprits did it, those things are not reconciled, so you have to let this information in. So it's a very how should I say, it's a very much a something like you'd see maybe in the old Soviet Russia, the way their trials were conducted, or maybe Nazi Germany or something. It's like really going off the rails here. AJK, yeah, substitution of counsel could take months. I'm just telling you, for the rights of Karen, if you have conflicted counsel, a counsel that's talked to her about the initial contacts, about what she thinks might have happened and all that. Number one, I don't know why that would be in text or email communications. You want to have somebody in your office. So it just looks bad. And in any event, it's going to get really unpredictable here, and what's going to happen. Like I say, I could see the whole trial not kicking off 1 April here. Yeah, I don't know why a judge on public coverage to the world would give the kind of ruling she's given. I mean, it's one thing if you don't have any media coverage, you can do whatever you want. And here we got live feed coverage. Wristband ruler, you're asking, do I think Brandon is trying to get rid of her counsel so he has more time? Also, thank you. Okay. Sofa jurors. I think I don't think he's asking for more time. I think that I think he hasn't thought this thing through. I think he has no clue what he's asking for. And just like I think the defense counsel didn't think it through by all these public statements that Karen made and how this could trigger a potential waiver. I think Brendan doesn't realize the can of worms he's going to open, how this could blow up in his face too, not just defense. Just me, you're asking, can the attorneys request a ground for sustaining objection or denying objection? No, that's what they asked for. They wanted to have the prosecution state the basis for the objection, and then they could make a rebuttal to that. And what's really troubling for me is that not only do they have not make us the basis for the objection, but the judge will rule on it right away before the defense counsel can even respond to it. So what normally happens with me when I get an objection and the judge makes a ruling like that, I'm like asking, Your Honor, could I be heard? And then I have the law behind me and the arguments to back it up as to why that should be allowed. My question should be allowed. And then most all times the judge will reconsider what they say and then deny the objection. And so here they're not doing that. And so that's why I was saying earlier that they should go up there every time there's an objection. They should say, we want to be heard on it. We're going to have a sidebar. Every time there's objection, there's going to be a sidebar. Unless it's something like rephrasing it and you know that you could rephrase it better. Because sometimes I've seen it where, it could be rephrased better by Jackson or whoever. But by just being pushed around by this this system where this objections don't have to have any basis other than to kill the momentum of the defense counsel's questioning of the witness, that's really disgusting to see. Dusty Blue, you're saying if the judge allows Crosby for the Commonwealth, she needs to allow Garrett Wing, the dog expert trainer, in his defense. His years of dog training dogs, et cetera, is stellar. Yeah, I agree with that. I totally agree with that. Okay, thanks. Thanks for adding that here, Officer. Proctor's on the defense witness list. Yeah, I mean he's got to be called. If the Commonwealth doesn't call him, the defense need to. Jeremy Howell, you're asking, have I looked into the recessed train track behind the Albert's house as a means for Colin Albert to walk unseen to the high school to be picked up by his cousin? I've not looked at that, but that's something I'll take a look at. Actually, Jared is saying trial one, they asked her to recuse herself. Why not this time? That's a good question. That's a good question. You know what the answer is going to be, but yeah, I think they should. I think they should push for that. Okay, let's see. Is there a way to complain? A's and you're saying, is there a way to complain about the prosecution of the judge? I mean, there's really not much you can do, and except appeal it. The judge hasn't ethically done something wrong. The prosecution hasn't, I don't think, ethically done something wrong, or they'd be in trouble with the state bar. But it's an issue that would have to be taken up on appeal. But these bad rulings, I mean, there's no way I think this case would ever survive an appeal. Wristband rule, you're asking, can the defense ask ARCA if Karen's insurance company hired them to avoid DOJ being brought up? I think the judge, based on the prosecution's position, I think the judge is going to allow them to bring up the fact that they were hired by the Department of Justice, U.S. Attorney's Office. But then what's going to happen is Brennan wants to get every single possible kind of communication between ARCA and the defense counsel, and he's going to try to smear him and rake him over the coals with that kind of information and put a spin on it. Tracy Watson, how does the judge allow Brennan to basically accuse the defense of colluding with the feds when he has zero proof? Well, he's already calling these defense experts biased, so they were just doing what they were told. They weren't trying to pick any sides. They didn't know who Karen Reed was. They probably had her name redacted. So it's very much a nothing but a smear campaign. It looks like from the state. Jennifer Rank, you're saying, have I seen the microdot video regarding Bev's ties to one of the parties? She apparently refused a scheduled evidentiary hearing, refusal to recuse strange behavior. I've not seen that. Yeah, it does. It's most unfair and unusual criminal case. Real Hollywood care is being railroaded. Like I say, I don't think you have to take a position of whether you think Karen Reed is guilty or innocent. What the way they're treating this case, it's just astounding. Auntie Lisa, you're asking if an appeal is necessary. Can defense note the judge did not bat an eye when revealed the video was reversed, but she gasped and had to excuse herself about the potential FBI payment. Yeah, they don't talk about things like that on the record in appeals. The demeanor of the judge and stuff like that. That does not come up in appeals. So don't see that happening. Jamie v. Ohio, how long did Diana Colby consider consciousness of guilt? Based on who wanted that research and when, that could be a sign, yes. Jen says that was something that Karen told her to do, and so that's but yet on her phone it indicates it was 2:27 in the morning. Okay, Mimi 3, you're saying Higgins ATF agent doesn't help the prosecution at all. I've never seen so many people get rid of their phones and lawyer up, I might add. Yeah, I want to keep the channel respectful. Luigi, hello. Can the judge be removed by a higher court in Massachusetts or the governor? The bias is obviously needs to be addressed. Bias isn't going to get you there. Biased rulings aren't going to get you there. If this happened to a lot of attorneys and they made a complaint and to the state judicial board or something like that, maybe some pressure could be put on her, but I just don't know if that's something that people want to do to stick their neck out. And then if they don't succeed, then they're going to be marked targets by the judge. Yeah, Morrissey should be kicked out of the office for his video. I think I want to cover that Morrissey video. Yeah, that's really, you just don't see stuff like that. It just shows you how they're just losing their minds up there in Dedham. Okay, we're at a little bit behind here. Yeah, see, you guys are still talking about D. Yeah, doubtful lawyer. Just some troll. Just Me says no crash report, no individual interviews, solo cup evidence collection, no chain of custody, distorted evidence, and Sallyport evidence collected in a paper bag from some kind of store. Lead detective gets fired for bias. All these butt dials, all this lawyering up. Nobody sees John O'Keefe out in the yard. Karen has an alibi. They can't get their story straight, their time straight. This is nothing but an open and shut not guilty due to reasonable doubt. Yeah, Jennifer Rank, D's behaving like the state. Shame on anyone who questions the state. We should all just accept the state's narrative. State has the burden of proof there was reasonable doubt in the story. Yeah, so no need to get ugly with people for having a difference of opinion. Leanne Doolin, you're saying Karen has another Massachusetts attorney that could sponsor them. Yeah, I don't know who that is. And maybe they don't want to get a sponsorship right away. Throw this thing into chaos. Yeah, I've been saying that I've seen that online that Canoni has the connections of Morrissey, and that he's the one that helped push for her to get the judgeship based on when he was a state senator or in the legislature. So if that's true, this could be a great explanation of why she's ruling the way she is. Teacup Kraken, you're saying Commonwealth wanted someone who willing to cross the line, distort facts, and spew vitriol. Yes, Tall Glass, it is normal for the judge to retry the same case. They're most familiar with it. But normally the judge is not the problem for getting a fair trial. Tall Glass, you're asking what defense witness would you think give the Commonwealth the most trouble? I think it's the ARCA witness. I mean, the ARCA witnesses are so credible, they're so professional. They have doctorate degrees in the areas that they testify to. And you compare that to Trooper Paul, who has an associate's degree, it's not even related to his field. So there's no comparison. There's no comparison. And like I've said before, I think Trooper Paul's never testified in any kind of murder case. I think he's only testified in accidents, and maybe there's, who, which way did the car spin out and crash and hit other cars, and what order did all this go down? And you get all that information from the witnesses. So it's not really complex, and it's not a job that a lot of police officers want to have. So yeah, Beachbum, you're saying Brandon's confused. The defendant has a right to a fair trial. Marta found a drunken disturbances involving death or bad enough, but when all the witnesses are drunk cops, that was doomed from the beginning. Excessive alcohol catalyst for the whole thing. Yeah, I mean, most all criminal cases I've worked, there's always alcohol involved, and especially hard liquor. If you have hard liquor, there's a lot of things can go go crazy in a hurry. Tom Moriarty, maybe not. Now, defense should object every 2 minutes. Eventually, the judge will be saying to the defense on what grounds. Yeah, I don't. I mean, you want to get through your witnesses. You want to be constantly objecting. I just think I hardly object when I'm at trial. I used to object more when I was younger, but the more I've tried cases, the more I'm like, I'm not worried about it because you know what? I got the truth on my side, and I can gun down anything that they try to prop up. And that's whether I'm a prosecutor or a defense counsel. Ava, you're saying the morning John's body was found when Karen was distraught and vulnerable. Do you think Jen the Hawk, I called her the Hawk last night, or she's watching out the door like a hawk at 34 Fairview, put into her head that she could have hit him? I totally agree with that comment. And I think that I think she then kept embellishing it to the point, like she said in trial for the first time. It's like Jen was saying that Karen was saying, I hit him," instead of saying, "Did I hit him? Did I hit him?" Or, I think totally Jen was driving the train on this to try to get Karen to doubt herself. And if she's drunk and doesn't really remember stuff, then she could say some statements, but she never did say, I must have done this or I did this. Because if she would have, I guarantee you that would have been something that Jen would have told over and over again from the get go. Joe Argos, in my opinion, the defense, including Karen, has a fear of Brennan. Otherwise, why the looks at him. Yeah, the one look that she had when they came into that Turtle Boy hearing, where she sort of gave um, this I don't know how to describe it. Other this like sort of like a like I'm disgusted with you kind of look, the way she blinked her eyes at him and turned around in her chair. It was something that I would not want to see as a defense attorney, my client doing something like that. It just does not look well, especially if you got all this media attention. If it wasn't for the media attention, it wouldn't be a big deal. But you got all this media coverage, so I would be telling my client, you just sit there, you're like a potted plant. You don't need to make any kind of emotional responses to anything going on in the courtroom. And if it's appropriate, like something like they're flashing up the images from the medical examiner, something like that would be you'd be allowing motions at that point. But other than that, the way somebody's responding and rolling of eyes or acting disgusted and stuff like that, I would tell my client, you need to sit there with a straight jacket on, control your emotions. Sure, as you're saying, all this makes sense if you understand there's neither investigation nor a trial but a cover up. That's a good way to summarize it. Sandy here, I've seen numerous medical professionals responding that saying that as a registered nurse, I'm telling you, if you do not have a bruise, you do not get hit by a car. Yeah, that's a good way to say it. Yeah, I'm not gonna call any attorneys names. I'm describing what they're doing, and Nikki, you're asking, do I think that we'll see a DOJ lawyer attending with ARCA during the board hours since Brennan has been pushing for so much info. No, I don't see that happening. State attorneys, they're not going to cooperate with him. I'm not going to try to say your name. Sorry, but you're asking how did I read or learn about the Betterow letter, and can Karen Reed defense use it against DA Morrissey? That had to do with some kind of conflict. I briefly saw something about that, but I don't see how that would necessarily have any applicability to Karen's case. Salem Spinks, you're asking, is very common for only a judge to handle jury selection and very suspicious, especially in this case. I do think that, depending on the type of judge, some judges allow a lot of voir dire questions and others are really tightly controlled. They want to limit the attorneys being able to ask a lot of questions. So it all depends on really where you're at. Linda Mon, you're asking, why does anyone talk about the basement? Yeah, that's something that should be discussed and brought up, because that's something the defense did bring up, and they brought up keep in mind that the double door that is almost laying flat against the ground against the house. That somebody could be taken outside the basement without going through the front door. And they gutted the basement. Where's the debris? Yeah, and the debris is long gone. But yeah, why did they change out the carpet? They said there was an overflow toilet. Beaky, you're saying, how can the defense bring up the inverted Sallyport video in trial too? Well, I think that they did bring that up in terms of that motion to suppress for outrageous government conduct. And so I think they're just going to make a big deal about the fact that the timeline of when they got this information still needs to be relevant and brought up on cross-examination of these different witnesses, because that is atrocious to not be given this information over to the defense. And the judge doesn't seem to be bothered by it. Just Kyle, you're saying, what would the Judge Canoni do if the defense just continually stated grounds for objections? Yeah, I mean, she'd just say, then she would say overruled, right? She would not say I'll allow it. She would say overruled. JC's asking, can you say any more about the video of Karen backing into John's car and the evidence that she already had her taillight cracked? Yeah, we see that the taillight is cracked beforehand. That's another thing that helps exonerate her, is the difference in the crack of the taillight from the time that she left John's house. They have it on the Ring camera. Also, how it looked when the vehicle was being towed away the next day at her parents' place, and then you compare that to what it looked like at Sallyport, you got a complete different look there. So I think that shows that some tampering was going on. And then you're talking about a video of Karen backing into John's car. I don't know what you mean by a video of that. We don't have a video of that. If she really did back into the car, there'd be so many people around, between Jen looking out of the house, even Higgins was looking out of the house. You also had Ryan there in his truck with a couple other witnesses. You had Julie coming out of the house and going back in. All that happened around the time frame before Karen left. She left around 12:29 to 12:30. And John wasn't there to be seen at the car at that time when she took off. So nobody saw him outside. So he got the evidence looks like he was placed there much later. So that's what is most reasonable to conclude. Sally Williams, you're saying you're all in for Karen Reed, but why did Karen kiss Higgins? What are your thoughts on that? I think she was, I don't know. I mean, she was drinking, number one. I think maybe he was really pestering her. He was really checking her out there at the bar and stuff like that. So he had some kind of fixation on her. And I don't think she really took him serious. And given the fact that she was drinking, I think that maybe it was also she had some moment of weakness because John, despite their 2-year relationship, I mean, he wasn't that committed to her. This being a long term kind of thing where they didn't get married, they weren't engaged, they didn't try to live together. She still had her own place. So you add all those things up, and so that sort of sets the scene better that way. But that doesn't discount the fact I think she did have feelings of love for John. But yeah, it was not a happy, totally happy, cohesive relationship. But definitely, there's no indications that she wanted the guy killed. So I think that's just so far fetched for the prosecution to argue that. Salem Spinks, you're saying you never thought anyone would hurt you more than Lally, but wow, Brendan's bad. Yeah, that's true. All right, I'm going to take just a couple more minutes. We're here at 11 o'clock, so I'm going to sign off. It's getting late. Thank you guys for supporting justice on this matter. Just one more question here. Does he believe you're saying it seems from trial one the jury needs to be schooled on what reasonable doubt is at the beginning, end of the trial, and the end? Yeah, that could be hit home much more because it is scary what we heard from that one juror, Ronnie. So thank you guys for being professional on this. Yeah, we can agree to disagree. If anybody here is thinking Karen Reed's guilty, I don't mind you coming on and chatting, but trying to be ugly about it, we're not going to tolerate that. So with that, I'm going to go ahead and sign off. You guys have a great week, and maybe covering again on Friday. And there is a hearing on Tuesday as well for this week, so I may cover that as well. Not sure about it. Depends if there's something I think is worthwhile talking about that night, as opposed to wait until Friday. So thanks for all supporting justice, and have a good night.